type. Hold my baby squid, keep them out of sight. Talking about my life, government stay away. If you drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my bed, protecting with my no government intrusion. I control my life.
There we go. Can y'all hear me now? Yeah, it was, for some reason, I just had to reset it. So let me make sure that everything is good now. Yeah. Okay. So it was fine, the fact that y'all couldn't hear me, because the little one was literally screaming the minute she heard our music. And it wasn't that she was screaming like she wanted attention. She was like talking into her mic, because my old mic is now her mic. So she's now, oh, hold on. You want this moved so you can get up there? Hold on. What? No, no, no. What are we? What? What do you want, baby? It's right here. It's right here. It is right there. You had it the whole time. Welcome to my Sunday morning. Mr. Squid is at work. So it's kind of we've had a good day. And, you know, it's all well and good and she doesn't want anything to do with me until I try to do something for myself. And then it's, you know, oh, you know what breaks loose. How is everybody doing this morning? It's kind of crazy around here. And I apologize for my voice. I'm still screwed up this morning. It's been a long couple of days. So I have my water here. Yeah, it was a long night. Baby Squid decided she wanted to get up at like 2:30. Mr. Squid got up or his alarm went off at 2:45. And then usually um I usually wait for his um like him to get up and start moving before I get up and do everything, because I don't want to go back to sleep and then him not wake up, and I'm that kind of person. I have to make sure that he got up and everything's good. He didn't move. He didn't move. He didn't move. He didn't move. And it's like 2:40. She's not going back to sleep. I don't hear anything. It's 2:45. Come here, baby. No. What do you want, Angel? This is how we're doing today. We're yeah. Yeah, baby. Yeah, honey. Whoa. What do we want? We're just not happy with anything, huh? There you go. Oh, thank you for throwing it at me. I appreciate you. Here, honey. Here. Here. You better not tattoo yourself, though. Oi. This is our y'all know, it's anybody who she's fine, she's fine, she's fine. Like, she's good all morning, she's great. The minute I log onto this computer, it's like, no, mom, no, 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 no. And she'll even go like, no, 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 no. So anyway, big day today. We are going to go through Sarah Boone's motion for a new trial. This was filed back in the beginning of November, and the state's response was filed on the 2nd of December. However, as most of you know, other things have taken some precedence and diverted my attention away from, Also, I'm going to give you guys a sneak peek to this. I will be covering this eventually. However, I'm not sure exactly when. This is what 2-year-olds do. And that's why I had to laugh when the hater channels told me or threatened to call CPS on me and all that. And like, I'm a bad mom, I'm this, I'm that. It's like, because I let her cry. Like, we have temper tantrums because I'm sitting down and she wants me to stand up. We have temper tantrums because I'm standing up and she wants me to sit down. Like, and I unfortunately don't have Megan's hold music on standby. But I do have that video on my channel. I clipped it. I read the letter from jail a couple of days ago. I want to say Thursday. We read the new letter. But this is this just dropped a couple of days ago, and I wasn't actually aware that this lawsuit existed until I saw Jules drop it on her Twitter. Bye, Spawn Trooper. This is a lawsuit that I will be covering wherever it goes. And for those of you who watched the Maya trial, this name will, please share. So, Dr. Goodhair is suing HCA Healthcare. So that will definitely be something that I will read tomorrow. Well, yeah, probably tomorrow morning, or tomorrow around noonish. It's going to be a busy, busy week of content. We have tonight's stream. Then we have this tomorrow. And then Tuesday, we have more of the depot reading with Brad. Wednesday night is night court. Thursday, we are doing more of government stuff. We'll probably get into where more of our money is going because we got a whole fiscal year left. So it's going to be a busy week of content. Hey, Captain. What the fuck is so early? Well, I'm sorry, you're in Colorado and I am not. Mr. Squid is at work this morning, so it's like the perfect time to stream. Because it's always easier to stream when he's not here. And he will be off work for 3 weeks-ish. His workplace does a shutdown for 3 weeks to a month. So for at the end of December and into January, he will be here all the time. So I will be streaming more and more because that will be my my time for me. All right, let's get into Sarah Boone's motion for a new trial, and we'll see what crazy she. Well, you bumped your head on the chair, baby. I can't help you with that. Like, there's some things that and we need. And this is why I said, yep, I'm done. Here, you have this though. You have that though. Because we decided to use the marker as a tattoo. Luckily, it's a dry erase marker, so it's going to be easy to get off. But that's ridiculous. I have 4 daughters, all in their 40s. Girl, I remember times I wanted to pull out my hair. You're a very good mom. Don't let anyone tell you otherwise. Thank you. I appreciate that. And there you go. She's taking her rag, and because she always needs to have a rag for her face, and she's wiping off her arms. I will help. I will help. These are her markers for her little cupcake set that she has. They're supposed to be icing, and they're just dry erase markers. So, but it's bath day today anyway. It's Sunday. Sunday is bath day, right? Sunday is bath day. Oh, come here, baby. Come here. Oh, you're fine. Here, you go. Oh, we're just having a day. Hey, Gabby. Baby girl. She's funny. I love her so much. Temper tantrums and all. She is hilarious. All right. Defendant's motion for a new trial. Oh boy. And we have the state's response too, which we'll get to. But this is the ridiculousness of Sarah Boone. And this was the last motion, I believe, filed by James Owens, because she's been appointed a lawyer that specializes in appellate law. They filed another one. When did they file another one? Because I just checked the docket Thursday or Friday. Let me. Flashman, are you messing with me? Because I literally checked it and downloaded everything Friday night, or whenever the last time I streamed. Because this is a new. Okay, hold on. Let me look. No, Flashman, this is the one filed this November 2nd or November 4th. This is the only motion for a new trial. And then we have the state's response, which is filed December 2nd. I just haven't had the time to get to it because it's been just so ridiculous of content and trying to get everything. I've been in the content, I've been drowning in content. You've heard that from Tug. Oh, and Flashman, check out Tug's stream from last night. He went through my emails to Bruce. So it was quite funny. I had wine. So I had lots of wine last night. And Puddletown, thanks for becoming a new member. Welcome to Tentacle Nation. It's weird. We're fun. We're a fun group. That umbrella guy. So he went over my emails last night. Oh, Debbie, thank you for the $20 super chat for the baby. She's so cute. I appreciate that so much. And my channel just got monetized in October with like super chats. And then like 2 weeks ago, I hit 1,000 subscribers, or 3 weeks ago. So we're the one thing the hater channels didn't count on was their backfired. Why isn't Gabby is a mod? Oh, where isn't Gabby a mod? She's one of the super mods on YouTube. Hey, Angel, come here. What? We're just unhappy with everything, huh? We're just unhappy with everything, huh? We're just an unhappy child this morning, huh? Girl, I don't know what you want. Literally, the only thing you're pointing to that you want is my keyboard, and you can't have it. That's you. No, you want a hug? Can I have a hug? Nope, she doesn't want to be picked up. No touchy this morning, huh? Flashing. All my mods are super mods. Like, come on. Ugh. I wish you would get a Cash App account. Yeah, I do have. Hold on. Let me put my banner across. I do have a Cash App, Venmo, and the PayPal's. So, like, I do have those. They aren't used as much lately, and I know. And I appreciate that. So, hey, hey, here, that is all for you. You want that, girl? I will be right back. I'm going to try to get her a snack. She just had a banana. Like she's all of a sudden went from being like a perfectly fine, content person just playing on her own to being angry at the world. Like I'm from everyone's chat. It's my job to talk a lot. Yeah, Puddletown. We go way back. I'm hold please.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young and it's just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. Afternoon, we lay awake in bed. The glass so loud as the hours pass. We're gonna do.
Hey guys, thanks for your cooperation. See, and she was fine when I wasn't at the computer. She wanted an ice cube, so I have a whole bunch of snacks here, in case she wants them. But she, when I was away from the computer, she was fine. Like she cried a little bit, but she was fine. And I get back to the computer, and it's she just has a thing where anytime I do something for myself, we have an issue. All right, let's get into this now that it's been 20 minutes and I've literally gotten nowhere. Defendant's motion for a new trial comes now the defendant Sarah Boone by and through counsel pursuant to Rule 3.6 Florida Rules of Criminal Procedure. files this motion for a new trial, stating in support there of the following. One, the defendant was found guilty as charged of second-degree unaliving on October 25th, 24. The instant motion is timely filed pursuant to Rule 3.6. 3, the defendant asserts that she is entitled to a new trial. Of course she does. Under Rule 3.6 on the following grounds. 1, the court erred in ruling that the defendant was not entitled to court-appointed counsel. I have a problem with that one right off the bat, because when you go through 8 lawyers, yeah, you don't, he didn't say she wasn't entitled to counsel. He said court-appointed counsel, because that she was wasting time and she was being difficult to the point where she was taking the court's time and abusing that privilege. Yeah, Rules of Criminal Procedures is back. 2, the court erred in denying undersigned counsel's multiple motions for continuance. He said multiple times, dude, this was 4 years. This crime happened in February of 2020. So she was delaying this for years. And the thing that I don't understand about that is because she thought that she was so innocent that why, if you think you're so innocent, why complain that or why try to delay? And Debbie, yes, I did get it. Thank you for the $20 Cash App for your beautiful daughter. Thank you so much. I appreciate it. I wasn't even a trial watcher in 2020. I was, but 2020 was a big year. That's when I had my surgery. That's when I moved to Georgia. I obviously worked in a hospital during the pandemic. So things were weird. So trial watching was not on my high list. I lived about an hour from Kenosha when Kyle Rittenhouse happened, and that was kind of my first I want to follow this trial because of the fact that it was so close to home. And then so it was kind of one of those that was my first parlay into this. Oh, and Flash Fan, we do, looking at the Colin Griffith case, we do have a date for trial. I have it written down somewhere. I think I'll update you on Discord, but there is a date for a trial or jury selection. When I'm done, I have it written down in my planner of legal crap. I have my planner for legal or for daily stuff, things I got to do, appointments I have, and then I have my big old planner for all the dates of hearings and things like that. So there's a date for the Colin Griffith case. For those of you who don't know, that is a Florida teen who is accused of unaliving his mother in Florida in Polk County. So it's Sheriff Grady Judd. And that is a year after he is not convicted because it never went to trial, but he unalived his father in self-defense. So it's, it is interesting. Your first was Maya Kowalski. Yeah, that was a big one too. On Wednesday nights, we are doing Vermont versus Joseph Ferlazzo. He is accused. And I think there was a verdict in this case on Friday, but we're doing it little by little at night. He is accused of unaliving his wife on their first anniversary van life trip. So it's yeah, we're doing a lot of different things on this channel right now. All right, back to this. 3, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. He is still bringing that up. I have a big problem with with James Owens for a lot of reasons. A lot of reasons. And this is a big reason. So funny story with the OJ. I was in 3rd or 4th grade, maybe both, because that trial was like 9 months. I will so we did recreations of that trial on the bus on the way home from school as 3rd and 4th graders. So my trial watching, lawyer acting, I'm not a lawyer, but my acting like a lawyer and looking at cases goes back to when I was 8. So we're going over 30 years here, you know. Plus, I like to argue, as y'all noticed. But I like to argue with a smile on my face, like a Karen. Yes, and I did just call myself a Karen. All right. 4, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, MD, after the state failed to disclose before the trial that the witness had formed a new opinion. And 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. James Owens, I understand that he has to represent his client, but this is reaching. This is reaching. Law and argument. Argument 1, the trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. 7 court-appointed attorneys. 7. And a couple of them were conflicted out. I think 2 or 3 were conflicted out. But still, 7 court-appointed attorneys. And she previously had a private attorney, Padilla, her first attorney, was not court-appointed. He was her 9th attorney. Let's let that sink in for a minute. 9 attorneys in 4 years. When I can see going through having a disagreement with 1, maybe 2. But like when you go through 8 attorneys, maybe the attorneys aren't the problem. Seven court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. And you possibly have the media rights to her story, which also breaks Florida rules of professional conduct. Just saying. Not that I've recently gone through that document and have that document saved to my computer because of another attorney who happens to be taking a case in Florida. Just saying. Just saying. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. Well, probably not now. It was apparent to undersigned trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. See Bowden v. State, Florida First District Court of Appeals 2014, and State v. Kelly 2008, and progeny. There appear to be 2 exceptions to this precedent. 1, if the defendant physically harms or threatens to harm his or her counsel, and 2, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's rights due to due process, as well as the defendant's right to assistance of counsel. In the instant case, the undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. Flash fan, you are my resident expert on this case because you watched basically every hearing with me. He warned her at least 2 attorneys back that if she kept up with her behavior, that she would lose her right to court-appointed counsel. And he also warned her of the impact that would have on her case multiple times, that it is not advised to go to trial without an attorney. So this argument is, this point is moot. I hate that word, but like, yeah, both judges warned her. Yes. Free ice rink, freezing rain in central Michigan. You can keep that one to yourself. I do miss ice rinks because my skates have a permanent parking spot right there. However, yeah. Yeah, really 41 watching and with 27 likes. Why is Bruce watching with you? Yeah, she had 2 judges too. And I think Judge Wooten was the last judge. And Sarah Boone praised her until she didn't get what she wanted. And then it was like, you know, you're disrespecting me and you're pouncing on my constitutional rights and all that. It's just ridiculous. Ridiculous. Under Puddletown member for 1 month, just renewed today and I'm 1 month, more like a year. Yes. Hey, Melissa, how are you this morning? They warned her over and over and over again, over and over and over again, over and over and over. Yeah, Puddletown YouTube is weird. And Tammy, thank you for the $25 Venmo. Merry Christmas. Merry Christmas to you as well. That is going to Baby Squid's Christmas fund. Or AKA Mommy and Daddy's credit card payment. Because Bruce wants to be Sarah Boone's new attorney. So, okay, this case has some similarity to the current case in Otter Creek, not because of the alleged crime committed, completely different, not saying that, but it's the a lawyer that takes on the case without knowing the history of the case. And then I don't know if Bubbles has done it, but James Owens blames the court for him not doing his research. This was 4 years of case documents to go through. People on YouTube know more about this case than James Owens did taking it to court. He tried this case, and there are YouTubers, Broken Baker, Mo in the Deep End, me, Melanie Little, there's Lawyer Good Hair, Lawyer You Know. Lawyer with the good hair is a lawyer you know this case inside and out, have followed it, have read almost every document, if not every document. And the lawyer that tried the case doesn't know about his own client. Like, I just can't, like, I know there's a lot of documents to go through, and I know he took it on short notice. However, that's not the court's fault. That's a you problem. So, Puddletown, thank you for the $5 super sticker. And Tammy, thank you for the 5 gifted Squid Pro Quo memberships. Oh my goodness. I just can't, like, sometimes with these lawyers, I'm like, I know I'm not a lawyer, and I know everybody's entitled to a defense. But it's like, do you believe your own bullcrap that you're spewing to the judge, or are you just trying to spew this? Like, I don't know. I feel like James Owens didn't know the shit he was stepping in when he this seems to be a pattern for Florida lawyers. I need to talk to Steve Gasney about if this is just a Florida thing because of their sunshine laws and the fact that like they have just a different way of doing things and a lot more transparency, or if this is just a lawyer thing. Because like all the lawyers that I've dealt with in my life have never done this. Yeah, Gosney is actually smart. There's that too. I always look at it this way. Having a college degree doesn't necessarily make you smart. Having a college degree means you can memorize things and take tests, or you know where to find things, which is half the battle too. But there is a difference, and I learned this after graduating college. The first year of my career, holy crap, there is a big difference between knowing the information and being able to apply the information. Those are two completely different skills. And in the medical field, I don't know about law school, not a lawyer, but they're in the medical field, we have practicals and like we have clinicals that we actually have to apply this stuff before we can graduate. It's graduating still a big learning curve when you go from being supervised to all of a sudden here's your caseload of 15 patients in a 9-hour day. Figure it out and make them and fix them too. So hey Pernilla, I'm here just lurking, just wanted to say hi. Hope you're having a great day. Happy Sunday. And hey Patrick, how are you? Thanks for the one gifted Squid Pro Quo membership. I love you guys this morning. Like one day I was looking, I meant to tell you one of the lawyers in kindergarten people worked with Steve Gosney. Yeah. One day I was looking for my phone and the person I was talking to said, hey, Gabby, you're on your phone. That's like searching for your sunglasses and they're on top of your head. So I am a occupational therapy assistant. So I only have an associate's degree, but I still have a degree. And that's why when one of my letters, I was like, I'm a college graduate and I prefer to act like it. Maybe you should too. I just like act like you have some sort of like, but I understand that lawyers spend a lot of time in books and just like doctors, and sometimes their bedside manner, so to speak, isn't their ability to people sometimes isn't the best. Just saying. All right. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for a new trial being granted. See Figueroa Sanabria v. State, 2023, Wilson v. State, 2000, and progeny. And I really hope I'm saying that word right. I tried, but Latin is not my thing. Under controlling precedents, Rule 3.111, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant, through counsel, moves court for a new trial. Argument 2. The court erred in failing to grant the defendant's motion for continuance made by undersigned trial counsel. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. Perozzo v. State, Florida 4th District Court of Appeals, 2023, and McKenzie v. State, 4th District Court of Appeals, 2020, Jones v. State, 4th District Court of Appeals, 2019, and Deal v. State, 4th District Court of Appeals, 2014. In the instant case, when the undersigned counsel came on board, the case was 4 years old. That's a you problem, not a court problem. And not a court problem. I miss playing jump rope with the cord. But that's just me. Congrats on 2.49K. I'm at 550, but still grew up. I remember when you had 10. So and that was not too long ago. So you were You are killing the subscriber game. And if you don't subscribe to Two Awesome Dogs, subscribe to him. He is awesome. He posts a lot of shorts of his rescued dogs, and they are just so stinking cute. And I don't have any pets. My landlord won't let us. So I live vicariously through pictures and stories about other people's pets. So, yeah. Undersigned counsel filed his notice of appearance on August 30th, 24. This gave counsel 45 days to prepare for a second-degree unaliving trial. He immediately and aggressively began to prepare for trial. Reading is hard, Heather. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions for meeting with Miss Boone and attending multiple hearings. The fact that you live in Milton and this trial was in Orlando is not a judge problem. This is a you problem. Like you knew where this trial was, and the fact that you this just to me is like, I'm sorry, you had 45 days to prepare. That's a you problem. That's a you problem. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Miss Boone's seized cell phone, viewing all records prior to contact of Miss Boone and alleged. I hate how he says his alleged victim. Like, George is dead. He's not an alleged anything. Your client was found guilty of unaliving him. She is no longer an alleged unaliver. She is just an unaliver. He is no longer an alleged victim. He is just the victim of your client, sir. You could get an emotional support dog. I'm sure you would qualify. I'm sure I would too. Yeah, that's what I'm saying. And I can see when your client has not been found guilty being an alleged victim, but she also used the battered spouse defense. So she was not denying that she was the one who did it. So alleged, his wording in this is like, you're just trying to be a douche. This is Douche Canoe 3.0. We have the original, we have Bubbles, and we have James Owens. Miss Boone's cell phone, viewing all records prior to contact of Miss Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Miss Boone being the aggressor at times. If it's on body cam that he said it to the police, that's not hearsay. I mean, correct me if I'm wrong, people who know more about the law, the detail of the law than I do, but if it's on body cam, hearsay is, I heard this person say to this person. Like, I heard Baby Squid tell her dad. Like, that is hearsay. Being on body cam, that's not hearsay. It is on a effing camera. Like, hey, Mr. Coop, how are you this morning? Oh, and I woke up with a giant zit on my chin, so when I'm like this, it's like poking a bruise. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with assistance of other attorneys, was simply logistically unable to prepare or be as prepared for trial as he would have liked to be. And Miss Boone was entitled to, under the controlling cases cited supra, the court's failure to grant undersigned counsel's motions for continuance should result in a new trial. Once again, this is not a court problem. This is a you problem. Okay, hearsay is any, and Jess is our resident lawyer. She is the smartest one in the room when it comes to the law. I love her. She is also the best at finding documents, followed very closely by Flash Fan. But Jedi Jess has the lawyer superpower of research that I just don't have. So a lot of times if you see documents that aren't in Florida, Florida is relatively easy sometimes because of their laws. They have to have it available to the public. But some of these other cases, there are people who are much smarter than me who help me. So if you see documents, they're either from somebody else in chat or they are from As the Gavel Drops. And I do have the As the Gavel Drops Discord link in the description of this video. Go give them a follow, join their Discord server for all the documents on all the cases you could ever think of. On body cam is fact and proof that is, well, but anything that happens, it is hearsay, but can meet an exception. But if he didn't object to its admission, then it's his fault. Yeah. Some of this is just like, it sounds like a you problem, not a court problem. So she's way better at finding them than me. Jess is awesome. Yes, Jess is amazing. Argument 3, the court erred when it denied a motion for new trial due to emotional outbursts in the presence of the jury. Prior to jury deliberations, the alleged victim, that word, I'm sorry, I just get angry at that word alleged. The alleged victim's family members began to audibly and get visibly upset and departed the courtroom. See, you said the magic words right there. Departed the courtroom. So they didn't create drama in the courtroom. Departed the courtroom means they tried their best to maintain courtroom decorum, which is where that right there makes his whole argument to me, be it I'm not the judge, makes his whole argument to me null and void. Like, sorry, you know. I looked up the cases he cites here, and the reactions in the cases he cites are way worse situations. That makes sense. And this, like, departed the courtroom right here, to me, means yes, although the family got emotional, they tried their best to maintain courtroom decorum, and when they couldn't, they left. That, to me, says respectful to the court. Also, they were outbursts by witnesses on the stand, not people in the gallery. Oh, there's the $1 million distinction. Of course they are. And I really hope the judge looks at that like you did. I'm sure he will, but and is like, well, this is like comparing apples to oranges. Hey, Kitty Ninja. Good morning. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outbursts could affect the jury's deliberations. They left. You said it right here, Mr. Owens. They departed the courtroom. Like, I'm surprised you didn't cite YSL. Yeah. Oh, he will, or at least research his clerk. So Judge Kranick has been very good at, with his rather large binder in front of him, having all these cases that the prosecution and the defense cite right in front of him. And it is, I don't know how he does it, how he keeps all that information straight in his brain, but and that's why he does that job and I don't. Sent you a pic of the red poinsettia Christmas tree at the casino by my house in Discord. I will look at that. Have a great day, Flash fan. We'll see you later. Florida appellate courts have held that failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. I'm going to screw this name up. Nebergal v. State, Florida 4th District Court of Appeals 2020, Smith v. State, Florida 2021, Colon v. State, Florida's 2nd District Court of Appeals 2016. The court is unable to determine if this outburst affected the jury's decision because no inquiry, it's Sunday, Under controlling precedents, the defendant is entitled to a new trial. Argument 4, the court erred in allowing the opinion of the state's expert not previously disclosed. Dude, just that statement without reading the page, my initial thoughts is he allowed Owens to depose the witness right there, right then and there. And the fact that James Owens was not prepared for that. Always be on your toes and be prepared for the unexpected. He's definitely not a Boy Scout. Just saying. Hey, Tamara. This sort is so patient. It was miraculous. Sarah Boone deserved what she got. Her opinion of herself was grandiose and ridiculous. Yes, the narcissistic traits are definitely real. She's singing, and you can see her shadow rocking back and forth. She's sitting on her chair. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October 4th, 24. The state committed prosecutorial misconduct by failing to disclose this new opinion, as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert, Dr. Tanya Werner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. Okay. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brannon and Dr. Julie Harper before expressing her opinion. She didn't have? Okay. Correct me if I'm wrong, please. But she didn't have to listen to this, the defendant's experts. And secondly, I would rather have a witness that formed their own opinion and not just went against what somebody else said. Because I know there are witnesses who just go against. Yes, she doesn't have to. Yes, she doesn't have to listen. And I actually would prefer a witness that didn't hear, because I know that witnesses for either side are just people who are paid to go against what the prosecution says. So I appreciate that she didn't listen to the defense's testimony, because that way she formed her own opinions and didn't make anything. Yeah. Yeah, she formed her opinions on Sarah Boone's statements. Exactly. Just Sarah Boone is an insufferable Karen. Yeah. Yeah. All right. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brand and Dr. Julie Harper before expressing her opinion. That's a moot point. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Moultrie v. Bethune-Cookman University, 5th District Court of Appeals, 2016. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible. Hunt v. State, Florida District Court of Appeals, 2019. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. Dubon v. State, Florida 4th District Court of Appeals, 2020. This testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. Lee County versus Barnett Banks, Incorporated, Florida, 2nd District Court of Appeals, 1997. Decision approved. So I'm just getting so frustrated with James Owens. Like, and this is one of the reasons that we had to do Sarah Boone Night Court, because this girl could not sit and listen to James Owens at regular speed. One, yeah, I don't have the time to sit for 8 hours and watch testimony, but James Owens is an insufferable douche canoe. Argument 5, the prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. With what facts? Wherefore, premises considered, the defendant seeks the relief sought herein, as well as any other relief to which she may be entitled. The defendant requests a hearing in this matter. I just like, with what evidence? That fifth, the second closing argument, like all the rest of these, you put, examples. And in that one, he would have 2 sentences. Where is your examples? Oh, wait, you don't have any. That might be why. Oh, this is that argument is stupid. Yeah, I agree. That argument is stupid. Yeah, and I'm thinking she won't. However, we have the state's rebuttal. We have the state's. Oh, that is a gorgeous tree. Let's see. Making it bigger. Well, you keep hitting your head on the chair. This wasn't a second closing argument, in my opinion. Want to watch a second closing argument? Go watch States versus Ashley Benefield for an example of a second closing argument. You're not the first person who I've heard say that. I didn't watch that trial. I know what happened. I did watch sentencing, but I didn't watch the trial in its entirety. Hey, girl, you keep hitting your head on the chair and then getting mad at me. Hey, silly girl. All right, let's get to the state's rebuttal. There we go. All right. State's response to defendant's motion for a new trial comes now the state of Florida, by and through undersigned assistant state attorney, and states and alleges as follows. Ground 1, court ruling defendant not entitled to court-appointed counsel. This ground is based upon things that occurred well before the trial began and does not appear to be a basis for the court to grant a motion for a new trial under Florida Rule Criminal Procedure 3.6. 2. Yeah. You want that? Okay. Look. You want the chocolate bar too? Chocolate bar, aka protein bar. But she just sees them as chocolate bars. Mommy sees them as gain weight bars. There we go. There you go. Thank you. Thank you. Yeah. She does. Well, she sits right here under, and she fails to realize that she's taller now. She still hasn't adapted to the fact that she's growing, and she, like even now, her little chair couch thing is under our dining room table, and she tries to stand up, and it's like now you're able to stand up, and you bump your head. Morning, Georgie. Hey, Higgles. How are you? All right, we are just getting into the state's response to the court's decision on this ground is well supported by facts and law outlined in the court's 16-page order dated June 28th, 24. 3, the court should not grant a new trial based upon this ground. Straight to the point, short, but the court wrote a 16-page order. Maybe James Owens didn't read it. Ground 2, court denying defendant's motion to continue. 4, this ground is based upon things that occurred before the trial began and does not appear to be a basis for the court to grant a motion for a new trial under Florida Rule of Criminal Procedure 3.6. 5, the defendant is overstating the holdings of the cases she cited. Perozzo v. State, Florida 4th District Court of Appeals 2023, McKenzie v. State, Jones v. State, and Deal v. State. Quote, the court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant continuance will result in a new trial should the court deny said motion for a continuance by new counsel, unquote, is not the holdings of these cases. 6, quote, a defendant's right to counsel of his or her choice is not absolute, and a court's consideration of any continuance should balance the defendant's right with a consideration on the impact on the administration of justice, unquote. McKenzie at 187, citing Alvarez v. State, quote, any denial of a continuance to obtain new counsel must be based on an adequate inquiry into the circumstances with findings to assure the defendant's constitutional rights were not being deprived. 7, the court's 16-page order dated June 28th, 24, adequately addresses the circumstances of the defendant's forfeiture to her right to counsel and the setting of a trial certain date of October 7th, 56 months after she was arrested for the crime. 56 months. 8, the court did not abuse its discretion by denying continuance in this matter. The case was over 4.5 years old because of the defendant's issues with multiple prior attorneys. My point exactly. Issues created by her behavior. The underlying work on the defense of self-defense and battered spouse syndrome evidence to be used in support of a claim of self-defense had been done by prior counsels. Much of the records disclosed to the state in October 2024 had been acquired years ago by prior counsels via subpoena and provided to private investigator Billy Lane. You didn't need to start from scratch. All the work was done for you. 9, the Florida Supreme Court requires only 30 days notice prior to trial for a defendant to rely upon battered spouse syndrome evidence. In this circumstance, with the expert already working on the defendant's case for years and relying upon the records the defendant had in her possession for years, it was the state that had only 30 days to handle this evidence after prior counsel had indicated it would not be filing a notice of intent to rely on battered spouse syndrome evidence. Oh. 10, while it did take time to review the entirety of the defendant's phone extraction, the state was able to do so in the same time frame and narrow it down to 167 pages of PDF timeline and 213 photos/videos. The phone extraction had been provided years ago to defendant's prior counsel. It was again provided to the defendant while she was pro se. The 911 calls and body-worn camera footage from the prior incidents took approximately a half a day to review. And that was accomplished after it was learned on October 1st, 2024, during her deposition, that Dr. Julie Harper relied on them. These were provided to the defense on October 4th, 2024. There was an entire week of no action taken by the court between October 7th and October 14th, 2024, because of Hurricane Milton. That and the prior 5 weeks was more than sufficient for a team of 4 attorneys and a trial consultant to review the material if the undersigned could. If I could do it, you could too. Yeah, she could have taken the plea deal and not going to trial and had 8.5 years. Exactly. And here's the thing, too. Well, I'd have a lot less content. Just saying. Because Sarah Boone is insane, in my opinion. She is a narcissist. Her attorney has some grandiose idea of himself. But and at the end of the day, we have to remember a man lost his life. However, this shit is ridiculous to read. And like it's the other gift that keeps on giving. 11. The court should not grant a new trial based upon this grounds. During the publishing of the exhibit, which contained image 0162-move, apparently a single family member of the homicide survivors had an emotional reaction and left the courtroom. The undersigned's back was turned and did not witness this. The family member did not return for the duration of this of the evidence presentation. It cannot be said that this nonverbal, single emotional outburst was so prejudicial as to vitiate the entire trial. I know I pronounced that wrong, but yeah. But neither could Amber Heard. There's a lot of people like that. A lot of women too. Yeah, it was only a gasp. And the fact that James Owens and the state both state that this person left. It wasn't like this person sat there sobbing, making a scene. They got emotional and they left. Oh, thank you. She's going to throw her wrapper in the garbage. It's kind of her new favorite thing, except when she puts my Stanley cup in the garbage. Then we have a problem. Talley v. State, Thompson v. State. Single outburst by victim during trial did not vitiate the entire trial. The trial court's findings on this situation are subject to an abuse of discretion standard, and the court did not abuse its discretion. The undersigned's recollection is that at sidebar, there was no request for a curative instruction, but rather a request to excuse the jury. The jury was excused, and the member of the victim's family had either excused herself or then excused herself. The allegation was then made that this was an intentional staged by the state. 13. It was neither intentional nor is it uncommon that a homicide survivor who has a right to be in the courtroom pursuant to Article 1, Section 16 of the Florida Constitution was mistaken in his or her belief about his or her ability to not become emotional during a trial. Nevergall v. State is distinguishable. There, the victim deliberately testified about DNA evidence on her backside belonging to the defendant, when in fact, that was not the conclusion of the DNA analyst, whose findings were inconclusive as to the identity of the evidence found on the victim's backside. Interesting. 15, Cologne v. State is also distinguishable as it involves the mother of a Smexy battery victim apparently needlessly being shown a picture of her daughter's private parts and throwing up in a trash can in the presence of the jury. There, a mistrial should have been granted. I mean, that's just... 16, Smith v. State involved a case where the medical examiner took a breath while testifying to the injuries the decedent had sustained and asked for a break. No error was found in the trial court's decision not to grant a mistrial. Ground 4, Dr. Werner's testimony. And okay, this is just me being picky about listening to, or about like the way this is typed up. This ground 4. Do you want to get up there? Okay, hold on. Mama help. Mommy will help. Hold on. There we go. Oop. Scoot back. There we go. There we go. Yeah, I don't want you falling off the chair, please. Trying to climb up there by yourself. Yeah, helmet. A law dad joke. Okay, so sidebar. Mr. Squid does not watch any trials, and he doesn't really pay attention to a lot of the stuff that I pay attention to. Hence why I have a YouTube channel, so that I will stop annoying him with stuff that doesn't matter. Like, you know. So he don't worry, Puddletown. I have one for you. He texts me this morning at 6:30. 5:55. So the Daniel Penny case, I heard that the majority of the jurors were Jewish, and this is not meant to offend anybody. And I was like thinking that maybe he had heard something about like, thinking that maybe he had heard something about the case, and like some of the jury members decided to speak out. And I said, it is New York. If there were cameras in the courtroom, I would have streamed it. This is where he goes dad joke. He's like, yeah, well, they just wanted to save a penny. Ha ha ha. Well, welcome to the dad joke. They have arrived. Like, Daddy thinks he's funny. So, yep, pretty much. It didn't hit the way he thought it would hit. But yep, oy vey. Oy vey. Oh, I get that. I went to sleep in the guest room because she was in bed with her father, and everybody knows they're both saunas, and I sleep hot, and I hate being warm when I sleep, and they are both human heaters. So I just took my place in the spare bedroom that I'm starting to take over. She wakes up at 2:30 and comes in there by me. I hear, Mom, Mama, Mama. And I'm like, okay, she's up. Like, she didn't want to go back to sleep. And then Mr. Squid was almost late for work. So it's I've been up since I got like maybe 3 hours of sleep after that. I think I woke up at 6:30, went back to sleep at like 3:30-ish. And hey, Tugsimp, how are you? Oh my goodness. All right, so getting back to this is me just being picky, totally being picky, and I'm more likely to agree with someone's arguments if they're easy to read and easy to understand. Ground 4, Dr. Werner's testimony should be on a new page. Just saying. Ground 4, Dr. Werner's testimony. The state understands the court's ruling at trial on the matter of whether Dr. Werner's opinion about the inapplicability of battered spouse syndrome evidence as a concept was a discovery violation and is not revisiting it for that purpose. Rather, the defendant has included this in her motion for a new trial, so the state will readdress it. The state is not required to disclose unrecorded oral statements. El Gomari v. State, Florida 4th District Court of Appeals, 2011. Unless it materially alters a prior written or recorded statement previously provided by the state to the defendant. The state deposed the defendant's expert, Dr. Julie Harper, as soon as possible after she was disclosed. The deposition occurred on October 1st, 2024. The very next day, Dr. Werner evaluated the defendant at the Orange County Jail at noon on October 2nd, 2024, given that trial was set to begin on October 7th. This was less than ideal for the state. The state was not provided the materials that Dr. Harper had relied on at that time, although the defendant acquired much of them years earlier. Dr. Harper's deposition had not been transcribed yet for Dr. Werner's review prior to the evaluation. The second defense expert Dr. Michael Brannon had not been deposed yet. After the defendant, in most material aspects, repeated her statements she made to Dr. Julie Harper that she zipped the victim in the suitcase and that they both initially thought it was funny, but she became angry after the victim stated he could not breathe. So she became violent with the victim and ultimately left him in there despite his stating he could not breathe and demonstrating his inability to get himself out of this predicament. It was Dr. Werner's conclusion that battered spouse syndrome evidence would be inapplicable. Immediately after the evaluation on October 2nd, 24, both parties and the defendant went to court to argue the defendant's motion to suppress. On October 3rd, 24, the state began reviewing the prior interactions with law enforcement that Dr. Harper said she had relied on during her deposition on October 1st, 2024, and arranged for body-worn camera and 911 calls to be provided to the defense team by Assistant State Attorney Dave Cacciatore on October 4th, 2024, while the undersigned was in Osceola County handling a placement hearing on a not guilty by reason of insanity, first-degree unaliving case. Later, on October 3rd, 24, the undersigned took the deposition of second battered spouse syndrome expert listed by the defendant, Dr. Michael Brannon. On October 4th, immediately after concluding the insanity placement hearing in the morning, the defense team took the deposition of Dr. Werner. Mr. Owens pressed Dr. Werner for any other opinions she may have, and Dr. Werner insisted on being asked specific questions. This is not a discovery violation, nor the creation of a prior inconsistent statement. The victim's failure to mention the two incidences in response to the defendant's counsel's open-ended deposition questions did not amount to a material change in testimony from the videotaped interview with Detective Martin, Detective Martin's report, or the victim's deposition. Because the victim's unrecorded statement did not materially change her previous testimony, the trial court ended the inquiry and properly concluded that the state was not required to produce the statement to Elgo-Hamari. This is indistinguishable from this case. Furthermore, the defendant was repeatedly placed on notice that the state did not believe, as a matter of law, that her statements taken in the light most favorable to her amounted to self-defense under Florida law. A discussion was held immediately following Dr. Werner's evaluation between the state and defendant's lead counsel to the effect when the defendant's lead counsel expressed that he believed the state should be lowering its offer to 15 years in the Department of Corrections because of what we all had just witnessed. The defendants say the state viewed the evaluation very differently and let defendant's lead counsel know why. Further litigation ensued immediately thereafter on the defendant's motion to suppress statements. Sweet Jesus. Yeah, she's asking for a new trial, and this is the state's response. It's ridiculous. It's ridiculous. Yeah. It's dumb. The defendant in her motion states the witness had formed a new opinion related to whether the defendant perceived an imminent threat at the time of the offense. The issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. This is just, he's just hitting them with facts. She is team captain on the Delulu squad. The word imminent does not appear in the entire 87-page deposition. It was not discussed. What the defendant stated on page 78 of Dr. Werner's deposition, according to Dr. Werner, was, quote, and she said, I saw him in the suitcase and I zipped him up and we were laughing. She said, then he stated he couldn't breathe. And I remember feeling I couldn't breathe when he was choking me or... Yeah, I'm not reading that. I like my YouTube monetization and I don't want to lose it. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. You were shaking it and it flipped over. A suitcase with a human inside does not flip over easily. We're not doing tire flips here, Sarah. Because she was never questioned on that opinion, there were no inconsistent statements to impeach Dr. Warner with. Hypothetically, if the defendant had gotten Dr. Warner's opinion on the matter during the deposition, the state fails to see what the defendant could really do about it other than disagree with it, because Dr. Warner's opinion did not violate Florida Statute 90.703, no more than when Dr. Harper rendered the opposite opinion. It was not an opinion on whether the defendant was guilty or not guilty. It was not even an opinion about whether the defendant used a justifiable use of deadly or non-deadly force. The opinion was about the applicability of battered spouse syndrome as a concept, given what the defendant had told her in her evaluation, and that because of what the defendant had stated in the above paragraph, it was inapplicable even if the defendant suffered from battered spouse syndrome. It was no different than Dr. Harper stating that the defendant met the criteria for battered spouse syndrome, and the defendant telling her she was in imminent fear at the time the defendant left the victim zipped shut in the suitcase. And that's just thinking back on it, that's just an awful way to go. That is just an awful. Yeah. She still thinks he did it to himself. If she just let him out of the suitcase, she'd be free right now. Yep. Yeah. And then she hit it with a bat. Experts can testify that a victim's injuries are consistent with forced Cruz v. State, DCA 1980, or Fourth District Court of Appeal in 1986, citing Fairness v. State, Florida Third District Court of Appeals 1983. Ooh, that's a throwback. Experts also routinely testify about the applicability of the insanity defense to a defendant. Quote, experts are routinely called to testify regarding the defendant's sanity in precisely these terms, the jury instructions on insanity. Medical examiners routinely, as in this case, testify to the cause of death, and it does not invade the province of the jury. Cardona v. State, Florida Third District Court of Appeals 2020. It is an opposite that the medical examiner's testimony contradicts the defense theory of the case. Identified at 1146 citations omitted. This is what happened here. Dr. Werner disagreed with the defendant. Because the defendant was examined by her own expert, Dr. Julie Harper, complied with Rule 3.216, Section E and F, and was examined by Dr. Warner, both experts were allowed to speak on the applicability of battered spouse syndrome regarding the facts of the case. State v. Hickson, Florida, 1993. The relevance of Dr. Warner not listening to the testimony of Dr. Michael Brannon and Dr. Julie Harper is lost upon the state. Ultimately, regardless of what all three doctors in this case testified to, the crux of the entire case was that even accepting the defendant's trial testimony, which was largely consistent with her statements to Drs. Harper and Werner, she failed to comply with Florida Statute 776.041, and in fact escaped having the forcible felony instruction read because of a statute of limitations technicality, a point which opposing counsel agreed with at the charge conference. Oh, yeah. Yeah. Neither one of them was an innocent angel, but this one is crazy. Request denied. Oh, yeah. She got into my music app on my iPad, or on her iPad. So I'm listening to her. Oh, so now I can't help but dance, sorry. This argument was permissible regardless of whether Dr. Werner testified or not. As a remedy, the court allowed the defendant to question Dr. Werner about opinions she was not asked by the state to give the jury, specifically whether the defendant suffered from any disorders recognized by the DSM-5 TR or met the criteria for battered spouse syndrome. She gave the following answer to the following questions during her deposition, page 3738. Question. Okay, all right. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? Answer. No, she told me that she was previously diagnosed with generalized anxiety disorder. So that would be in there. She's been prescribed an anxiolytic for that to help treat her symptoms. Whether it is a generalized anxiety disorder versus an adjustment disorder, to her being in the facility is questionable for me in all honesty. But I haven't had time to go through everything thoroughly since I just saw her 2 days ago and process everything in all honesty. I think she also has narcissistic personality traits, which was evident in the evaluation. And those would be my two major diagnoses. I am not down that rabbit hole. So, yeah. And I believe this is why she didn't take the plea deal. Because if she took the plea deal, she would have to accept responsibility. And Lord knows we can't do that. Page 46, question. But you don't believe that she suffers from PTSD, in your opinion? Answer. No, I would have to look back through my notes to see if she fully met that criteria. Pages 57 and 58. Question. Is it your opinion that Sarah Boone does not suffer from battered spouse syndrome? Answer. No. Again, I would have to go through my notes to fully formulate an opinion on that, but I think she certainly was involved in a violent relationship. Question, but you haven't formed an opinion one way or the other about whether Sarah Boone suffers from battered spouse syndrome. Answer, I think I want to go through it to make sure, but I believe that there was a lot of violence in her relationship. She described being threatened. She talked about, the different kind of violence cycle and the different aspects of it. So most likely she does. I don't have an issue with that. At trial, the defendant was permitted to explore Dr. Werner's opinions on these matters. The defendant was also allowed, without objection, to bolster Dr. Harper's testimony by reciting passages from Dr. Lenore Walker's treatise on battered woman syndrome. Duss v. Garcia, Florida 1st District Court of Appeals, 2012. Experts cannot, on direct examination, bolster their testimony by testifying that a treatise agrees with their opinion. This was accomplished by asking if Dr. Harper recognized the book as an authoritative, and then reading quotes from it. Likewise, without objection, the defendant cross-examines Dr. Werner with quotations from this treatise, with neither her nor the court recognizing the publication as authoritative. Cross-examination of an expert with and I know I'm saying this word wrong, treatise is only permissible if the cross-examined expert or the court recognizes the publication as an authoritative treatise. For the above stated reasons, the court should deny the request for a new trial on this ground. Ground 5, the last one. Alleged prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. The defendant, much like her motion to suppress statements, cited no authority to support this ground being improper or grounds for a new trial. This, of course, is no bar to her again alleging prosecutorial misconduct. Quote, the proper limit of a rebuttal is a reply to what has been brought out in the defendant's closing argument, Brown v. State. Quoting Brown v. State from the 4th District Court of Appeals, 2019. Whoa, that was the same case, 2 different Court of Appeals in 9 years apart. The state strategically broke up its closing arguments. The first argument was nearly entirely devoted to why the defendant was guilty of second-degree unaliving. Obviously, there is some inevitable crossing into why it was not justified and why the defendant lacked credibility, but that was largely left for rebuttal. The defendant's nearly 2-hour-long closing argument centered on why she met the criteria for battered spouse syndrome. It touched upon why this made it objectively reasonable for her to fear imminent harm or death if the victim escaped the suitcase, but failed to address the applicability of Florida Statute 776.041 to the facts. And the facts were that she left the victim shut in the suitcase after he said he could not breathe and asked to be let out so that she could make him feel how he made her feel in the past. And she could say whatever she wanted to him, and he had to listen to her. It was completely fair rebuttal to distinguish the difference between a defendant's subjective belief that something is necessary versus objectively reasonable for a cautious and prudent person in her circumstances. Likewise, it was fair to attack her credibility as a witness, and that was the foundation of her defense, and to point out that even if the defendant's arguments were accepted, she failed to comply with Florida Statute 776.041. Like, the double cite means the court issued two different opinions, could be co-defendants with the same last name or two different appeals. Yeah, what it sounds like is that it's two different appeals. That's two different appeals. So I'm assuming the first one, the 2018, cited the appeal from 2009, but I could be wrong. I have to look it up to make sure. So, at least, I mean, some of the things that the defense said was like, you don't have stuff to back it up. Remember, the fifth argument in the defense's motion was 2 sentences long. There was nothing cited. So the fact that he did basically a page and a half or a whole page to with citations is interesting. I like receipts. I like facts. I don't like someone's opinion. And all that James Owens said in that fifth argument was his opinion. Oh, feel better, General T. Bad case of the flu and pneumonia. And I hope your father-in-law is doing better. Ugh. It was completely fair rebuttal to distinguish the difference between a defendant's subjective belief that something is necessary versus objectively reasonable for her to be cautious and prudent person in her circumstances. Likewise, it was fair to attack her credibility as a witness, as this was the foundation of her defense, and to point out, even if the defendant's arguments were accepted, she failed to comply with Florida Statute 776.041. Conclusion. There is no right to jury nullification, like we state. The defendant was placed on notice several times that her versions of events did not amount to a justifiable use of force under the law. A, the state's motion to strike the defendant's notice of intent to rely on the defense of battered spouse syndrome, and state's motion in limine, and state's motion for examination by state expert, September 11th, 24. B, state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome, September 19th. C, state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, October 7th, 24. D, state's request for forcible felony instruction and request for initial aggressor instruction, October 24th. State's request for special jury instructions regarding withdrawing from physical contact, October 24th. No version of the defendant's events amounted to a justifiable use of force due to her only stating that she became afraid after she had become angry and aggressed the victim by choosing not to let him out of the suitcase because he made her angry when he said he could not breathe. She was going to make him feel like he had made her feel in the past, and she was going to say whatever she wanted to say to him while he was a captive audience. She admitted to what Florida statutes described as a forcible felony of aggravated assault. Florida Statute 776.08 and 784.021. She was allowed her 10 days in court to ask for jury nullification with past incidents of violence committed by the victim. The court should not grant her a new trial. And then certificate of service. And that was William J. I mean, I like that response was longer, but it was to the point, provided receipts, and was like, no, bitch, no new trial, no new trial. She said in her letter that she ran to the neighbors many times, but none of the neighbors backed her. Yeah, that one neighbor said that she saw her with bruises, but like I have a bruise on my arm. That doesn't mean it was done by anybody. It means I was a klutz and I ran into something. Like, I bruise easily. Maybe Sarah does too. Yeah, vengeance, not fear. She didn't care. She figured once it's out, it was out and people heard it and she knew it. They can say court ignored it or whatever. But once it's out and she knew it. It's just so, I don't know. Like, I understand that every lawyer, most lawyers, I'm not going to say everybody, I'm not going to make an all or nothing statement, but most lawyers, they do whatever they need to and they file whatever they need to defend their client. I know that I've seen multiple trials and I've never seen a trial that a lawyer didn't ask for the charges to be dismissed before closing arguments. Like, you have to do what you have to do, but when you're doing it, don't make stupid arguments. Like, I'm not a lawyer, but I feel like I could be a just a writing, an English professor, like a writing class. Like, why'd you do that? Like, that's not how we do this. I have a scratch on my inner upper arm above the elbow that I can't for the life of me figure out how I managed to get it done. Doesn't mean it's from my husband. Yeah, I was looking in the mirror this morning and I have a bruise on the back of my left calf. I have no idea how it got there. Not a clue. Who knows? It could have been a sleep injury because I am sleeping on the guest bed and it's got a metal frame or a different, it's lower and stuff. So when I get in and out of it, I might bump the corner of the frame, which don't have to worry about on my bed. But like, I could have been even, it's right where the chair hits the back of my leg. So I could have been like bored or antsy and swinging my legs and hit it. Who knows? All I know is just because you have a bruise doesn't mean it's from another person. Like, hey, Gabby, thanks, Squid, for the live. Got to get going now. Hope everyone has a great day. Thank you, Gabby. Good to see you. Hope you have a great and relaxing Sunday. Lawyers don't usually go against their ethical obligations for a client. Yeah, there is that. I mean, we've seen a lot of them lately. I feel like most lawyers that I've covered lately have a few ethical issues. And James Owens will be my next video on ethics because of his supposed reason for being paid or how he's being paid, which is against Florida bar rules of professional conduct. I've cut myself before, bleeding be everywhere. No, yeah, I mean, I've done that too. Like, just when I was younger, my dad had a different house, and he had a fireplace with like a stone hearth, and the stone had to be this thick, and the top and the bottom edges of it stuck out. And I walked by it one day, and you had to pass by it in order to get to the kitchen. And I scraped it on my left leg. And then turning around and walking back into the living room, I scraped it on the other side. So I literally had matching double scrapes on both my legs. Too many bad lawyers. Yeah. Many lawyers ignore ethics altogether. Yeah, that is true too. So I think I am going to call it a day. I just wanted to get through these because of the fact that we've had a lot going on, and these were a couple of things that I let slip through the cracks. However, we do have a trial date, and I have to look it up. For Colin Griffith, he has a January 14th hearing, and I will be going over his stuff either Monday or Wednesday morning. I'm not sure whose I'm going to do first because we have Colin Griffith stuff to catch up on, and we have Dr. Corcoran's lawsuit against HCA Healthcare, which I might do that tomorrow because that is brand new, and then do Colin Griffith on Wednesday because Tuesday is the deposition day. So, like I said, it's a busy week. I am trying to find where I put this in my calendar, and I don't know where I put it. I have it all like, but when I do have it, I will let you guys know. I'm gonna see if I can look at Polk County access right away. Polk County is another one of those counties that's super easy to it's super easy to look up. Oh. The only thing is you have to type which court. And I didn't. There's a hearing 12/13, and I couldn't find any of that on where it was streamed at all. There's a hearing date 1/27, 1/21. Jury selection is 1/27. So we should have a trial at the end of January, beginning of February for Colin Griffith. Trespass 5 is at 1 p.m. Thumbnail is at 2 p.m. On what date? February 5th. Yeah, it's gonna be a busy month. Just good for crows. You've noticed ever since you called out the Nunya accounts that there's no Nunya ID showing up in any chats now. Yeah, interesting how that works. And then that person goes and lies about it. Like the fact that I am from the Milwaukee Waukesha area, but I live in Georgia. So I still follow like WISN 12 and Fox 6 Milwaukee channels on Facebook, but ask the Wilborns how much I go on Facebook. I even have a Squid Pro Quo Facebook page that I started, and I have to Puddle Down. Well, there has always been in Megan's chat, going back, I want to say at least a year, Nunya Business or Nunya Bitness. That is an actual person, not a troll. And then there's a few Nunyas in the Fleas chat, but none of the ones that were here. Faye, I moved to Georgia in the summer of 2020. So, but I will look into that. There's also a couple of cases from Wisconsin that I kind of want to cover. So look up WEAU. I will do that. So I'm going to get going. Do you want to say bye? No. Okay. She's busy. I was born in Forsyth. I kind of like Georgia. I'm in between Savannah and Augusta. So yeah. But I will see you guys later. I am going to do some one, I have laundry in that I need to go switch over. It's sheets and comforters day. And then I will oh, thank you. Oh, you're talking about this? She sees my headphone and she handed me a rag. She's pointing at my ear. Like I'm bleeding. Oh, poor girl. Thank you. Oh, you're so sweet. You're so sweet. Thank you. Yeah, I love you too. She's still looking at my ear like fix it. Y'all have a great day, and I will see you tonight, 8:30 Eastern time. We are doing Unhinged on the internet. Since the hater channels called me unhinged, I decided to make a show. So that's where I let chat derail me, and I have things to talk about, videos and stuff, but we just let the whatever happens. So y'all have a great day, and I will see you tonight. Stay blessed. You want to say bye? She's waving. Have a great day, guys.